So now in this point we'll be talking about, in this part we'll be discussing the special codes, new insertions, one time read. These are one time read. So first point is 67A, the establishment of special codes. See, these points which I am reading, these are in the CA final law, economic law, same thing is there. So anyways, this is given even in your foundation module, newly inserted in LLP, but this is less important for the exams, but it's better to read it at least once. That's why I'm doing this. Now let's get into this point. What they are saying for this is that establishment of special courts. See, special courts, no. The central government may, first we'll read what they're saying, then I'll explain what properly, okay. With in easy language, simple language, I'll explain. Establishment of special courts. The central government may, for the purpose of providing speedy trials, of the offences under the Act, by notification establish or designate as many special courts for the area and for necessary for such area or the areas as may be specified in the notification. That is subsection 1. Next, part 2, section 2 or subsection 2 or point 2 is saying that special code shall consist of the special code which the central government will establish now for the purpose of speedy trial. It will establish a special code. Who will establish? Central government for the speedy trial in such areas. This special code, no, it will consist of at least a single judge who will hold the office as a session judge or additional session judge. Okay. And one more important word is that in case of the offense is punishable with the imprisonment of 3 years or more, and metropolitan magistrate or a judicial magistrate of first class in the case of other offences, who shall be appointed by central government with the concurrence of the Chief Justice of the High Court. Understood. What they are saying is that first of all, the central government will establish the special court for speedy trial. Point number two is that the special court will consist of a single judge who will be presided over by special judge, session judge, or the additional session judge in case of offences which where the imprisonment is 3 years or more. Two is that a metropolitan magistrate or a judicial magistrate first class, he will take over such cases in other cases, means which are less than 3 years. In case where the offense involving imprisonment less than 3 years, the metropolitan magistrate or the judicial magistrate will take over a first class, who shall be appointed by central government with the concurrence of the Chief Justice of High Court. You might be wondering who the session judge is. Session judge is nothing but those who are appointed by the government itself. Okay, they will handle the criminal cases, especially the criminal cases they will handle where the imprisonment is more than three years or so, 3 years or more. If it is less than metropolitan magistrate or judicial magistrate of the first class, they will be lower. They always think that session judge is more higher and metropolitan magistrate is lower compared to the session judge. Okay. Next, coming to next part of the provision is that they are saying that the special courts in particular cases is not designated yet. In such a case, section 435 courts which are established under section 435 will be deemed as a special court. Okay, that's all. Next point is that same thing they have explained it a little bit further. You don't need not see this point, it's fine. Okay, next coming to section 16, next is section 67B, procedure and the powers of special court. Procedures and powers of the special court. So let me explain this point in a simple manner, okay, so that you don't have to go into that all the technical language. See, what they're saying here in this point is 67B is that procedure and power of the special court. We established special court in the point number 67 here, right? In 67B, what they're saying is that where all the offences which is specified under subsection 1 of 67A, in 67A we read that in subsection 1 the offences we read now here, the offences which are established, all those offences shall be trialable only by special court, which is designated or established for the area in which the registered office of the LLP is situated. See, where the registered office of the LLP is situated, where they committed the offence, no, where they committed the offence. In such area, there will be a designated special court will be there in the area where they committed the offence, the LLP. The registered office of the LLB is stated. In there, the designated special court is there. There, the offence will be trialable. The offence is committed where or there are more than one special courts. Means suppose there are more than one special court in that area, there are two special courts are there. Then the High Court will intervene and they will tell which special court the LLP's case will be trialable. That's what they are saying here. That the offence is committed or where there is more than one special court for such area, by such one of them may be specified in this behalf, while the High Court will specify which is there, which special court they have to go. Next point number two is that while doing the trial now, a special court while trying an offence, suppose there is any other offence which the accused has committed under the Code of Criminal Procedure 1973, be charged at the same trial. Means if there is any other case also is there against him under Code of Criminal Procedures, that can also be trialable in special court because same powers is given to special court as well as per Code of Criminal Procedures. So that's what they are saying in point two. Point number three, this is a little bit important from the exam point of view. It can be important, but I can't say for sure. Okay, this is usually focus area will be there of ICI. Now, what they are saying here is that, see, we read that similar powers as Code of Criminal Procedure is there for special court. The special court may, if it thinks fit, try in summary way any offence under this act which is punishable with imprisonment for a term not exceeding 3 years. See, next also point also I'll read and explain together because it is linked with this one. Provided that where in case of conviction in similar summary trial, no sentence of imprisonment for a term exceeding 1 year shall be passed. These 2 points you have to read it on your own. No, these 2 points you have to read it together to understand. These 2 points you have to read it together to understand. What they are saying here is that special court no. When they are doing the trial, if special court thinks that this is a case where the imprisonment is less than 3 years, so if it is less than 3 years, the imprisonment, where the imprisonment less than 3 years, they'll think that the court will say that let's do it in a summary way, the trial. In summary trial, what happens is that in summary trial, the conviction means the final verdict which is given in the past by the court of final order in the summary trial. In such a case, summary trial conviction or the final verdict should be that the imprisonment for a term not exceeding 1 year means the imprisonment should be less than 1 year. The result or verdict or the order passed by summary trial if the imprisonment should not exceed 1 year. It should be less than 1 year. Means summary trial can be conducted only in a case where the final verdict will result in an imprisonment which is less than 1 year. If it is more than 1 year, see that's what they are saying here is where the commencement or in the course of the summary trial, it appears to the special court that the nature of the case and sentence of imprisonment exceeds 1 year means if the imprisonment, the verdict, final verdict or the order of past conviction will exceed 1 year, in such a case it can be tried in a regular trial can be conducted. This is procedure. Just they have to mention that procedure. If it exceeds 1 year, now the final verdict in a summary trial. If special court thinks that, then the regular trial should be conducted. So that's what they are saying. I'll just read it for your satisfaction. What they are saying after this point that a special court that the nature of the case such that sentence of the imprisonment for a term exceeding 1 year may have to be passed or that is for any other reason undesirable to try the case in summarily. Special court shall after hearing the parties record an order to that effect and recall all the witnesses and examine and proceed to re-hear the case in accordance with the procedure of the regular trial. That's what they are saying in this section 67B. In this section 67B, if you ask me, this point is important. This point is important, and this is a little bit important. That's all. This much you have to read. Next, coming to section 67C, appeal and revision. See, this section is nothing is there in this. 67C, appeal and revision, what they are saying is that the High Court may exercise so far as may applicable all the powers conferred by these chapters of Code of Criminal Procedure. If the special court has a special court within the local limits of jurisdiction of the High Court or a court of specials trying cases within the local limits of jurisdiction of High Court. What they are saying is that if there is no special court is established in local limits, then in such a case the High Court within its jurisdiction will try the case as a special court. That's all. That's what they are trying to tell here. that the jurisdiction of High Court where court of sessions trying cases within the local limits of jurisdiction of High Court. That's what they're saying. Next, coming to section 68A, registration offices. So registration officers, what they are saying in this point is that and above functions which have to be performed by the LLP, right? It should be performed to perform those functions. The central government has to regulate it, right? They have for regulation. They are establishing number of registration offices at different places to regulate the LLPs. So to register the LLPs, for them to function, for them to perform their duties, for them to operate the LLPs, they have to register. No, they have to register where they'll register. The central government will establish number of such registration offices. That's what they're saying here is. The central government may appoint as registrars, additional registrars, joint registrars, deputy registrars, assistant registrars as it considers necessary for registration of the LLP. Like I said, for registration of LLP, the central government will appoint registrars, additional registrar, joint registrar, deputy registrar, assistant registrar as it considers necessary. They will have such powers and duties as per the terms and conditions of their service. Okay. And central government, this point is a little bit important for us. Central government. Central government may direct the registrar to prepare a seal or seals for authentication of documents required for or connected with the registration of the LLPs. The central government may direct the registrar to prepare its own seal and seal of authentication. Suppose the LLP gets fake registration and use fake registration and says that we are registered with the central government. To prove that it is a fake document, the central government is telling that to the registrar to get its own seal, prepare a seal for authentication of the documents. That the particular LLP has a valid document of registration. Okay, that's what they're trying to tell in point number 4. I hope you understood this. And next point is the payment of additional fees. See, this point is very simple. What they're saying here is that when you're filing a particular form in LLP for registration only for taking as an example for registration of the LLP with the central government with the registrar, we are filing online with the application for LLP, right? That application we have to pay a fee to file that application. Particular fee is there. Suppose the document has to be filed within a particular due date, and we did not file it within the particular due date. Means you are filing it after the due date. So what happens in such a case? You have to pay the fee for the form. That original fee which you have to pay for the form, it will be there. Plus the additional fee will be there for filing it late. Means after the due date, if we file, no, it will say that additional fee will be charged. That is what they're saying. Payment of additional fee after filing, after the due date, if you are filing, they have to pay the original fee and the additional fee which is there for the late filing after the due date. That's what they are saying in this section 69. You can just read it on your own, which I have given here, and with given the points which are important in this paragraph. Also, I have give it in italics. You can read it once, and you will be able to understand. So that completes the amendment video for this LLP 2021. So I hope you have understood it, and just see this video at least once or twice. You'll be able to understand it even better. And if you like the video, just give it a thumbs up and subscribe to the channel so that I will bring more content for you guys. And good luck for your exams. Thank you. Study well.